Record in docket 22-03307. The state of Michigan versus Glenn Skeen. Will the parties please introduce themselves for the record?
Jake Whiskey on behalf of the people.
May it please the court, David B. Carter Jr. on behalf of Mr. Glenn Skeen, who is present and standing at council table.
Sir, you are Glenn Skeen?
Sir.
All right. This is the time set for preliminary examination. Mr. Wisty, how are we proceeding?
Your Honor, my understanding is the defendant will be waiving the 21-day rule and we will be adjourning this morning. People will also waive the 21-day rule. The reason is Mr. Curry was recently appointed on this case.
And is that your understanding, Mr. Carter?
It is, Your Honor. Also, my client has been housed in Shiawassee County, and I haven't been able to go over everything with him. I had the opportunity to do that today, and we will be perhaps even looking into a counteroffer, but I think it would be beneficial if this case got adjourned out. I discussed this with my client. I discussed his rights of having this held within 21 days of his agreement. I indicated to him I'm requesting this so I can be more prepared, and he indicated he was willing to waive that.
All right. May I inquire your client of his 21-day rule?
You may.
All right. Mr. Skeen, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. Do you understand that, sir?
Yes, sir.
The 21 preliminary examination is a probable cause hearing in which the people of the state of Michigan would have to prove by probable cause evidence that a crime was committed, a felony crime on this file, and the identity of the person who committed that crime. All that should take place within 21 days. If you waive your right to a prelim within 21 days, you will not be waiving your right to a preliminary examination only within that 21-day period. It's my understanding you wish to waive your right to a prelim within 21 days so that your attorney who was just appointed can get more information and do more discovery. Is that your request today, sir?
Yes, sir.
So it's your intent to waive your right to a prelim within 21 days?
Yes, sir.
All right. I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. We'll reset the prelim for...
Your Honor, if I may, I think it would be more beneficial if we set a PCC, if that's
Okay,
possible.
sure.
Perhaps January 5th.
Can we put it? What's the closest we can get to PCC date?
I believe this case will get resolved without a prelim.
All right. We don't have any PCCs, do we? We do it on the 13th?
Judges. PCC, or it would not be until January.
All right, so I'll give you an option, Mr. Carter. We can do it since I have to go to new judges school because evidently I have to be taught to be a judge at this point. So I'll be taught everything I'm doing wrong, okay? We can do it we can do it in December, the last week, or we can push it to the week after I'm back, which is the 21st,
19th.
the 19th. So the 19th or
December 29th.
or the 29th. For the PCC, right?
I'll take the 19th.
All right, so we'll do it on reset PC for January 19th, 2023 at 8:30. And I placed in the file, the writ still needs to be done out of Shiawassee, right?
Yes.
Yep.
Yeah, let's get an exam date too, just in case. So the PCC's on January 19th at 8:30. And then just to hold that.
The 26th at 8:30.
And then the preliminary examination will be the January 26th, 2023 at 8:30. Just as a holding place for it now. And I have a writ needed out of Shiawassee for both dates.
I'll update the court if in fact he gets moved. He's got two cases, one in Shiawassee, two other cases, one in Shiawassee and one in Davis. So if I get information that he has been moved, I'll let.
All right, thank you. All right, so the probable cause conference, sir, is on January 19th at 8:30, and the preliminary examination will be January 26th at 8:30. You'll be read out for both those dates, okay? Anything else for the record, docket 22-03307, Mr. Whiskey?
No, Your Honor.
Anything, Mr. Carter?
No, you're on.
All right, if I don't see you, have a happy holiday, okay?
Thank you. You too.
On the record in docket 22019883, that's people of the state of Michigan versus Cameron Thornton. Will the parties please introduce themselves for the record?
Jake Westy on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter, appearing on behalf of Cameron Thornton, who is seated to my right.
And sir, you are Cameron Thornton? All right. Mr. Wisty, this is time set for a motion on bond. Did you want to be heard before or after, Ms. Sutter?
After Ms.
Okay.
Sutter, it's the defense's motion.
All right. And we've had some preliminary discussions about this, but Ms. Sutter, you may proceed.
Thank you, Your Honor. Mr. Thornton is currently being held on a no bond hold. In this case, he was originally given a $1,000 PR bond. He was scheduled for a CFP interview that he did unfortunately miss. He did turn himself in on that warrant that resulted from that. And he's been held in custody since then. My understanding was he was to be held in custody until either the CFP interview was completed or the preliminary examination was held. I reached out to CFP, asked them to reschedule another interview with him, which they did do, and that was completed last week with Dr. Rowland. So his CFP interview has been conducted. His preliminary examination has been taken off the docket, and from what I've seen, he has a forensic review date out in February. And my understanding is that's about the timeline we're looking at for the CFP report to get back to us. In the meantime, what would happen is Cameron would be held in custody until that time. I would like a bond for him to be set. Specifically, I would request a personal recognizance bond, given the kind of circumstances here. I understand there is a failure to appear at an evaluation hearing. I sent for competency for a reason. I think Cameron struggles to understand and remember things, in particular some consequences, and it kind of takes living these consequences to have a full understanding of them. He's obviously lived those consequences now. In addition, he's got some very serious medical concerns, in particular epilepsy, which results in frequent grand mal seizures. Those grand mals are kind of at the foundation of this case as well, but they are certainly at the foundation of why he's having some memory issues. He does have the heavy and very supportive community network of, in particular, his wife, who is incredibly involved in his court case. She reaches out to me frequently with questions and updates. She's incredibly beneficial to him in terms of getting to court dates, getting to appointments with me, taking phone calls with me. He is too, but she is another outside source who is incredibly helpful to him. So I think a personal recognizance bond would be appropriate for Mr. Thornton, as well as sufficient to continue him coming to court hearings, in particular, since we don't have any until February for that forensic review, waiting on that report from CFP. So I believe the prosecution has some release requests to make, but I would ask that a bond be set, in particular, a personal recognizance bond for him. Thank you.
All right, thank you. Ms. Wisty?
Yes, Your Honor. I believe there's no criminal history here in the nature of this charge. The people will leave whether or not to be a bond. Court's discretion. We would, if there is a bond to be granted, we would request conditions that he follow up with mental health treatment, get an evaluation, or follow up with recommendations. So that would be the people's position on the motion this morning.
And I've expressed the prosecution's desire for mental health follow-up to Mr. Thornton. That's not an issue for him.
Has he been seen by CATS?
Not to my understanding. He's been seen by the Center for Forensic Psychiatry.
Okay, and you're just waiting for the evaluation.
Correct. Dr. Rowland completed the evaluation with him last Wednesday, I'll pull up the exact date, the 7th.
All right. You have a $1,000 PR bond that was initially set, and then it was remanded by Magistrate Faulkner because of the mental health.
The failure to appear.
Yeah, the fail to appear. So my take on this is that I'm willing to set a low cash bond today. The PR bond didn't work last time for whatever reason, but I would take that and make it $1,000, 10%, which is $100 PR bond. Because of the fail to appear, it's hard for me to give you a PR bond since he failed to appear on a previous PR bond. That'd be silly for me to follow that up. You understand that this is that your attorney is really asking for the opportunity for you to be released. So I'm going to indicate $1,000, 10%, which is and then with the following conditions, that you're to follow up with mental health treatment, all right?
All right.
However that's decided, that you need to follow up with treatment in regard to that. It's an assaultive crime, it's an R&O, but it's a lower assaultive crime, and you have no prior criminal history. So I think this is a nice balance for yourself in regards to making sure that your medical and mental health needs are met. But another failed to appear, and we're right back where we started. Okay, so so just understand that. Okay. Anything else? So $1,000, 10% is the ruling of the court on the bond for the reasons stated for the record, with follow-up to mental health treatment. Your following bond conditions are the same if you're able to make bond: no alcohol, drugs, no assaultive behavior, no out-of-state travel, no firearms, and to report to pretrial services within 48 hours.
And Your Honor, would you like him to do that via pretrial services or seeking out mental health services on his own?
Mr. Wist, did you have a preference?
I would defer to the court. If pretrial services can help him, I think that would.
I think if pretrial services can help him, let's start in that regard. I mean, on some level, you're the best. You know somewhat of where to reach the best assistance for whatever ails you. And we're going to be waiting for a forensic report, but let's start at pretrial services to see if there's something that they can set you up with right away. Okay. All right. Anything else for the record in docket 2201983, Mr. Wisty?
Nothing, Your Honor.
Ms. Sutter?
Just to confirm, he must follow mental health services, did you say within 24 hours of release?
Within 48 hours of
48 hours
release.
of release.
Yep.
Thank you.
Uh,
I have nothing further.
So, Mr. Thornton, we'll see you
Thank you.
probably by February, okay?
Okay.
All right. Good luck to you, sir. Okay.
At home, do you still have the number for pretrial services?
Um,
Okay, almost.
Yeah, I don't know if he's even.
All right, we're on the record in docket 22-02526. That's people of the state of Michigan versus Lance Travis. Will the parties please introduce themselves for the record?
Twisty on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of Mr. Travis, Your Honor.
Okay, this is the time set for preliminary examination. Mr. Wisty, how are we proceeding?
Your Honor, the defendant is not here. As a result, the people would be requesting a bench warrant without a 40-hour hold, as this is assault crime.
Mr. Feigelson?
Yes, Your Honor. I know he appeared at the probable cause conference. I did check the Eagle County Jail. He's not there. Whether he's in another jail, I don't know the answer to that. I know this is the first time he's not appeared. I'd ask if there's gonna be a warrant, gonna be out to the end business today to see if I can figure out where he is and secure him over to this court, Your Honor. I do know it's
It was-
9:40.
Yeah, it's 9:40. He's got 5 minutes to, to show, but you don't expect him here.
At this point, no, that doesn't mean he won't be here.
Right. So what I'll do is since it is this is an assaultive crime, isn't it? So it's discretionary. It's GBH and a domestic assault. So I'm going to issue bench warrant and bond forfeiture. Defendant failed to appear. Mr. Feigelson, if you're able to get him here today, we'll of course, entertain setting a bond. But at this time, I'm going to issue a bench warrant and bond forfeiture for his failed to appear.
There's no one in the waiting room, I assume, Judge?
No, there's nobody in the waiting room. And I'm willing to hold on to the file till 9:45. He's got about 6 minutes.
Okay.
Okay, but right, so DFTA bench warrant bond forfeiture at this time, and then if he shows up today, bring it to our attention and we'll see him. Mr. Wisty, do you have witnesses here?
I'm not sure if we.
Okay.
Your Honor, we have witnesses. I don't know if they're here.
Right, I understand. All right, so I'm going to issue I'm going to issue the bench warrant without a 48-hour hold. Mr. Feigelson, let us know if he's able to make it today. And I'll just hold on to the file for the next 6 minutes until.
Judge, he's not in custody anywhere in the state, so.
Right.
I check fine.
All right. So at 9:45, I'll just make sure and call. Okay.
I'll let you know, Judge.
All right. Thank you. So that's all for the record at this point. 22-02526. 02526. We were waiting for Mr. Travis to appear. It still seems like he has not appeared. Now we're past the 9:45. So I'm going to issue the bench warrant at your request, okay?
Thank you, Your Honor.
All right. For your indication, it was set at $1,000, 10%. Okay.
10,000.
I'm sorry,
10,000.
$10,000, 10%. $10,000, 10% on the GVH. All right. So we're on the record. Let's do the prelim file first. That's 3117. Right, we're on the record in docket 22-03117. That's People of the State of Michigan versus Leona Mathis. Will the parties please identify themselves for the record?
Jake Wisty on behalf of the people.
Karen Robinson, Assistant Public Defender for Ms. Mathis.
And this is the time set for preliminary examination on this file. Mr. Wisty, how are we proceeding?
Your Honor, the defendant has failed to appear. We'd be requesting a bench warrant. This is a property crime, so the 48-hour hold, I believe, is appropriate.
And this was set for 9 o'clock. It is now 9:52. I do have this set as a larceny building property crime. Ms. Robinson, any comment?
We would just ask for the 48-hour hold as well, Your Honor. Thank you.
So the court will issue defendant failed to appear, bench warrant bond forfeiture with a hold for 48 hours
Thank you, Your Honor.
pursuant to the crime. Anything else for the record in docket 22-03117, Mr. Wisty?
No, Your Honor.
Ms. Robinson?
No, Your Honor. Thank you.
Thank you. That's all for the record in this file.
She is notified.
She does, I don't,
There's also a misdemeanor.
it's a
We
misdemeanor
moved
file.
it to this morning. Show up on the back.
So, yeah, so just put that with the, on our statute docket. Because it's not a felony.
We were gonna hear it this afternoon, since we have a statute docket this afternoon, so I moved it to the morning, so she don't have to appear once.
Since there's a 48-hour hold on it, should we just maybe leave the file for like 1:15?
Yeah,
we
I
can
think
do it
that,
then.
I think
Sure,
that's
that's
probably a
great.
good idea.
I'm gonna put it back on for this afternoon.
All right,
Just
Awesome.
Oh,
Thank you.
I'll set
for
it
the
aside.
formality.
There's the larceny building. Oh, that's the one that was not even on the docket.
Yeah.
Okay.
So this is- I know. Sometimes the music is like,
All right, so we're back on the record in docket 22-02526. That's People of the State of Michigan versus Lance Travis. Will the parties please introduce themselves for the record?
Jake Westy on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, on behalf of Mr. Travis, who's standing to my right, Your Honor.
All right, and sir, you are Lance Travis?
Correct.
All right. This time set for prelim today, just to indicate some of the history here. Mr. Travis is late today. It was scheduled for 9:30. Post 9:45, the bench warrant was issued for fail to appear, although I indicated to Mr. Feigelson that if he got his client here, and his client was on his way here, so this is the time set for preliminary examination. The bench warrant is quashed, so there's no bench warrant. Mr. Wisty, how are we proceeding today?
Your Honor, I would request an adjournment or a reset of the preliminary examination. If the court would give me a brief recess to go see if any of my officers are here, I suspect they are not. There was a bench warrant.
Right. All right, go check. And this is I believe this is an R&O.
No, this is assault with intent to strangulate, Your Honor.
Okay.
And
GBA.
and a domestic. Miss Bonilla is not in the building, Your Honor.
All right.
Expected today. Doesn't mean she's not here. But I just haven't seen
All right, we'll wait to see if Mr. Wisty has any witnesses here, and then we'll
her. We'll
go forward.
Thank you, Judge. Thanks for
Right, the 29th.
Mr. You might have plans with. Right. So back on the record, docket 22-02526, Mr. Wisty, the defendant was bench warranted, so.
Yes, Your Honor, my officers are not here. I believe there's good cause in the circumstance for an adjournment.
Okay. I also agree that there's good cause for an adjournment. I have looked at because the bench warrant was issued for the defendant.
Judge, I don't know if there really is, and I'll get to the point if I can be heard.
Okay.
It was 5 minutes late. We thought it was the 30th Circuit. Miss Bonilla is not here. We can adjourn this out next week. Every day for the next year, she's probably not coming. I can't say that for certain, but when we bring officers in, we do victimless prelim, we just sit on a circuit court docket. We're ready to go today. They can always refile if this reappears. I'd ask for a dismissal.
I understand. I'm gonna grant the adjournment for good cause. We did issue a bench warrant. I have that the defendant did not get here till 9:56. It was 9:30 when this was scheduled for. So timeliness does matter in this regard. I will give you 2 dates so that you can see which one works, because one is closer to Christmas.
I'm here. Judge.
Okay,
It's
so-
the fastest day we can
so-
get it on the docket.
So the fastest date would be the December date.
December 29th.
So- So it's adjourned for good cause.
Let's do 9:30.
Adjourned for good cause because of bench warrants. And it's adjourned to December 29th
29th.
at 9:30. All right. So this is adjourned to December 29th at 9:30 for preliminary examination. Mr. Travis, it's 9:30, you're in this courtroom, so you know where to come. Keep in contact with your public defender, Mr. Feigelson. You have any questions? And we'll see you today. We'll see you on December 29th at 9:30. Okay, sir? All right. Anything else for the record, Mr. Wistine, docket 22022526?
No, Your Honor.
Anything, Mr.
No,
Feigelson?
Your Honor, thank you.
All right, thank you. That's all for the record this file. I'll let you deal with the bench warrant. I tore it up that one time and with the understanding that there's Killebrew of no upfront jail. So I'm gonna direct you to probation in order for them to set up a program for you, okay? And they'll indicate a report for me to come back for sentencing. Do you understand that, sir? All right. So you should go or be contacted by probation within,
If he's still in custody, I should contact him within about 72 hours. If he is only held on this, once he pleads the misdemeanor, the 7-day period goes in effect.
all right.
So he should report to probation by Tuesday.
All right, so if you're not in custody, okay, and I don't know if you have other cases out there, you should report to probation by Tuesday of next week. Do you understand that? Okay, if you're in custody, they'll come see you within the next 72 hours, all right? All right,
And Your Honor, I'd actually like an opportunity to address Mr. Sorrell's bond
all right.
when the court is ready.
All right, sentencing date.
February 1st at 1:30.
The sentencing date will be February 21st, 2023 at 1:30. And Mr. Nicola, you indicated you want to be heard on bond.
Yes, Mr. Sorrell's is being held on a low bond, but unfortunately, because Mr. Sorrell's is homeless and because of some terms of incarceration over the past year on some cases have been getting resolved. He is without income in order to pay that bond. It was issued because a warrant was issued when he was not present by the time the court called the case the last time we were here for preliminary exam. I would note, however, that Mr. Sorrells was actually present in court that day. He waited for over 2 hours while the court attended to other matters. Mr. Sorrells and I had many conversations about possible resolutions. He wanted me to discuss a modification to the offer with Mr. Wisty. And I told him if Mr. Wisty did not agree to that, and likely the court would reset the date. I believe that led to a miscommunication that Mr. Sorrells felt like he was going to get a new date. And so he did not remain, but he was here. He did attend his court date. We did have many discussions. He's now resolved this matter. He understands the importance of reappearing for sentencing. He did spend 15 days in jail recently. Also, this arrest came on the back of him being arrested on a warrant. And so this case was actually pending for about 6 months, most of which 6 or 7 months before he was arraigned, most of which he spent in the Ingham County Jail in custody. And so there is some delay there that they could have gotten this to a resolution much quicker. I just the court give him a PR bond at this time, an opportunity to report to probation and then reappear for sentencing. Like I said, he has appeared for his prior court dates. And when he missed one of the court dates in this case, he immediately called me and did appear on the Monday to get that addressed. So he is certainly not looking to run from this case or avoid it in any way.
Mr. Wisty?
Your Honor, I do think there is some risk of him not appearing and failing to plea on probation. On the other hand, as the defense points out, he's done a lot of time on this, and in some ways, the benefit of the bargain is almost absolved if he's sitting waiting for sentencing. So I would leave this in the court's discretion.
Yeah. I do have a failed to appear on October 13th, but that was on at the initial arraignment. But I also have a long note indicating that after he was indicated failed to appear, he was actually here. No bench warrant was issued. So he actually showed up. He actually took care of his responsibilities. So I'll take a chance. All right. I'm going to PR bond you. PR bond. It's a PR. I'll set it at PR $1,000. You're to report to probation within 48 hours. If you do that and you come for your sentencing on February 21st, 2023, I don't think we'll have any issue. All right. So just do what you're supposed to do. If you have any questions, keep in contact with your attorney, Scott Nickel. But I think Mr. Wisty's right. You've got a Killebrew, no upfront jail. Yeah, I mean, you've got the benefit of the bargain right now on a 1 year. And if you fail to appear for sentencing or for probation, then we have an issue. All right. So the best thing you can do is take care of your responsibilities. All right, sir?
Yes.
And so make sure you have Mr. Nichols' number so that we can, so we don't have an issue. All right? All right. Anything else for the record? Docket 22025592, Mr. Wisty?
Nothing from the people.
Anything, Mr. Nichol?
No, Your Honor.
All right, Mr. Strells. We'll see you on February 21st. All right, sir? All right, thank you.
PR bond today.
You got PR bond today. Report to probation so they can follow up, okay? All right.
That's good.
Record in docket 2203192. That's People of the State of Michigan versus Courtney L. O'Reilly. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good morning, Your Honor. John Abbott, representing Ms. O'Reilly. She's present in the courtroom.
Ma'am, you are Courtney O'Reilly? All right, thank you. This is the time set for a preliminary examination. Mr. Wisty, how are we proceeding?
Your Honor, we'd be seeking an adjournment of the matter. Sorry, I'm hearing voices. We'd be seeking an adjournment on the matter, Your Honor, for the reason that Mr. O'Reilly has a pending forensic and another matter. We're awaiting results on that before we decide how to proceed.
All right. Mr. Abbott, is that your understanding?
Yes.
All right. So the defendant is out. Is the defendant willing to waive the right to a prelim within 21 days in order for the adjournment?
Yes.
All right. May I inquire of your client of their waiver of the 21-day rule?
Yes.
All right, Ms. O'Reilly, you understand you have the right to a preliminary examination within 21 days of your date of arraignment. Is that a yes, ma'am? All right. And a preliminary examination is a probable cause hearing in which the people of the state of Michigan would have to prove by probable cause evidence that a crime's been committed and the identity of the person who committed that crime. Do you understand that, ma'am? Okay, you of course are represented by Attorney John Abbott, and he could contest any charges, cross-examine any witnesses that are brought against you. Do you understand that? It's my understanding today that you're going to waive your right to a preliminary examination within that 21-day period in order to seek more discussions and negotiations concerning any type of review by another agency. Is that true, ma'am? All right. So is your intent to waive your right to a prelim within 21 days? Okay. You'll still have a prelim. It just won't be within 21 days. I find that the waiver of the prelim to the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. And we will reset. Do you have any indication what?
She's got the interview is next week,
It's on January 18th.
January
January 18th. So sometime after January 18th.
January.
We have the forensic review currently scheduled for next week, Mr. Abbott.
Did I read the date wrong?
I need to ask you for the question.
Oh, I'm
please.
sorry.
So, okay,
So in the last 90 days, they haven't contacted her for the forensic evaluation.
They just sent us a letter this week.
I
and
just got it this week.
Okay, just a second.
I just want to make sure we set it out with plenty of time.
And you said January 18th?
Yes.
I'm just gonna set a forensic review. It wouldn't be on the record necessarily. It's just a date to hold the file so it doesn't age incorrectly. We'll just set the forensic review for February 2nd.
All right. So
On
let's,
both files.
so
I'm gonna
on-
change the other file.
on both files, let's set for forensic review to make sure we know the status. That would be on February 8th. That would make the prelims, that would make sure that the prelims were set after the review status. So we'll set it for February 2nd,
Just the formalities at 9:30.
Is it the second or the eighth?
the 2nd at 9:30. And then we'll wait to hear from the
February 2nd?
February 2nd will be the preliminary examination, but that'll be after your whatever evaluation's
I'm not
done.
I'm just setting reviews. I won't set the, we can't set the prelim until we have the forensic.
All right.
competency hearing.
So that'll just be a review control date to make sure we have the paperwork to set it for prelim, okay?
Does she need to be present for that?
Probably not, okay? That's really just for our purposes to make sure before we set it for prelim. So keep in contact with your attorney, Mr. Abbott, and he'll let you know when the prelim's actually set, but we just want to make sure we have all the paperwork before we get there, okay? So the 21-day rule has been voluntarily waived. We've set a control date, for lack of a better term, or review, for February 2nd, 2023 at 9:30, and at that time, we'll revisit the correct time to set the prelim. Anything else for anything else for 22-03-192 from the people, Mr. Wisty?
No, Your Honor.
Anything, Mr. Abbott?
Nothing from the defense.
All right, Ms. O'Reilly, please keep in contact with your attorney, Mr. Abbott, okay? All right, thank you.
Thank you.
Thank you. Have a good day.
You too. So Daniel can bring them both up.
So I just put this case to forensics.
on two files. This is filed docket 22-03113. People of the state of Michigan versus Omokinovo Ijo. And also on file, co-defendant file 22-03290. It's people of the state of Michigan versus Siban William Jackson. So will the parties please introduce themselves to the record?
Good morning, Your Honor. Crystal Murphy on behalf of the people on both files.
Good morning, Your Honor. John Abbott, representing Mr. Ejo this morning.
Good morning, Your Honor. Jacob Sars, the fourth, appearing on behalf of Mr. Saban Jackson. He's in the jury box. He's standing by.
All right. So, sir, you are, and you'll help me pronounce your name, Okominovo Ijo?
Omokinovo Ijo.
Okay. And sir, you are Saban W. Jackson.
Yes.
All right. Thank you. This is the time set for a preliminary examination today. Ms. Murphy, how are we proceeding?
Your Honor, the parties, myself, both defense counsels and Your Honor had a discussion back in chambers in regard to the conflict that is of no fault of anyone's at this point in time. But regarding the two defense counsels being from the same public defender's office representing the two co-defendants, it's my understanding defense will be asking well, I'll say this. When we talked in chambers, there was a discussion of there being good cause to adjourn. The court agreed that there would be good cause to adjourn. And with that, I believe we would be looking at a January 5th date.
And the good cause being at this point in time, we have a conflict. There's a conflict that both co-defendants are represented by the public defender's office. Mr. Abbott, I'll allow you to speak first in regards to how we're proceeding on behalf of Mr. Ijo.
Thank you, Your Honor. I did speak with my supervisor this morning, Mr. Cornish, and we've identified the conflict, although a little late, but and he'll be seeking substitute counsel. I'm very likely for my case, Your Honor. So that I'll be withdrawing from the case and I'll be appointing substitute counsel for this case. Before I go, Your Honor, I'd like to make the court aware that Mr. Ijo is under the supervision of Judge Kennedy and is scheduled to start TRICAP counseling. Actually was scheduled earlier, but couldn't go because of the hold from this case. I'd ask the court to grant him a personal recognizance bond on this. It's currently $7,500, 10%, which is more than the family or his loved ones can afford. If we grant him a personal recognizance, Your Honor, I believe he can start there at TRICAP, and if necessary, bring him back from there on the 5th.
What's the current bond in circuit court, or does he have a bond in circuit court?
I don't know.
Yeah.
Oh, it's civil court. It's $200, but the judge dismissed. Just say the kids don't have nothing to do with it because since I went to prison back in 2016, bond was $200. So he told me just Okin, Wisconsin or something will I have to take it with me or something.
My concerns is I PR bond him on this case. There's nothing holding him on the other case, and then we got a problem.
Yeah, I think he's awaiting transport to TRICAP as soon as he's released from this case.
Okay, Ms. Murphy.
Your Honor, the people would object to any lowering of the bond. If I'm not mistaken, I believe the bond in this case is $7,500, 10%. It's a very reasonable bond. This defendant has a lengthy criminal history involving assaultive crimes, gun crimes, and now he was in jail on a plea on a drug case, and here we are again with another charge and another crime. I don't believe that speaks too well of him being able to follow the court's orders, follow the court's rules. It's a reasonable bond, Your Honor, and the people would respectfully ask that the court leave bond as is.
All right, I because of the nature of the bond in the case and the criminal history that's somewhat extensive, I'm going to leave bond where it is, $7,500, 10% at this bond, and then if he's incarcerated and we have to writ him out, we'll writ him out. But at least I know where he is, as opposed to not knowing where he is in regards to this file.
Your Honor, can we modify the bond so that if he's released to TRICAP, he can be released from Union County Jail?
Yep, yes, absolutely. So I don't think there's any problem as long as we know where he is, if he's released to TRICAP. Then we can make arrangements to have him writ here. Because that's for treatment purposes, but at least I know where he is, as opposed to not knowing and then we run into the same problem. So the defendant may be released to TRICAP for circuit court case. But still on bond on this case. And then, Mr. Sarts, would you like to be heard? And then we'll address the new date. Mr. Sarts?
Thank you, Your Honor. Mr. Jackson understandably is quite upset about the situation. This case, when it was originally issued, only had Mr. Angio listed as a witness. However, when the matter was reissued, after that previous case had been dismissed, Mr. Angio was then charged as a co-defendant in this matter. So Mr. Jackson understandably is upset about the situation, Your Honor, but I do believe there's good cause. There would be a very clear conflict of interest here. And as a result, we'd request the matter be adjourned out until January 5th, albeit Mr. Jackson is very upset about the situation. We'd like to proceed today. Thank you.
Understandably, so the court will adjourn both cases, 22-03-113. Mr. Ejo's case for conflict counsel to step in since we have a conflict in regards to the public defender's office representing both co-defendants. I find good cause, therefore, on the same file, since it does seem to be the same witnesses, to adjourn for good cause Mr. Jackson's case to wait for conflict counsel to be assigned to Mr. Ejo. I find that to be good cause because of conflict, and it's a co-defendant case. And so we'll get a new date of.
January 5th at 9 o'clock.
So the new date is of January 5th at 9 o'clock. January 5th at 9 o'clock. Understand to both defendants, since this conflict was not any fault of your own, that you have not waived any rights today. You've not waived the right to a 21-day rule in any regard. I just want to make sure that we have the appropriate counsel here because the office is conflicted out in regards to one of these cases. So we'll see you back here for preliminary examination on January 5th at 9 a.m. Anything else for the record, Mr. Abbott?
Well, thank you.
Anything, Mr. Sarts?
Nothing further, Your Honor.
All right,
Thank you.
please keep in contact with your attorneys and they'll keep you apprised of any information. Ms. Murphy, anything else?
No, Your Honor.
All right, that's all for the record on both of those files.
Thank you.
Y'all have a blessed week.
You too.
Mr. Porter.
Mr. Porter and Mr. Chain. Well, January 5th, they did a big handy.
Yeah, well, I try to look at that 3-day to kind of just contrast.
I mean, you see the civil hearings that come up and some,
Well, and I try to like use that,
Right.
those days to clean up.
That's why it's easy for us to take care of this right now, because we were discussing his place in line,
So
and he may have fixed that for us.
I'm gonna give him a quick call. I
Okay.
believe Mr. Wissy's gonna be asking for an adjournment.
22-02320 is the first file. We also have a 22-02496. This is the time set for a prelim in these matters. Will the parties please introduce themselves for the record?
Nick Whiskey on behalf of the people.
Good morning, Your Honor. John Abbott representing David Cheney. He's present and seated to my right.
Sir, you are David Cheney?
Yes, sir.
Okay.
Judge, she's not connected yet, so she's.
She just left. Anyway, so let's go to 22-02320 first, and then we can address through commentary the second file. Mr. Wisty, it's my understanding we have two files. How are we proceeding today?
Your Honor, on 23-20, we will be proceeding with the preliminary examination. On the other file, that would be 24-96. I have spoken to my witness. There were a number of issues here, but I think what has transpired this morning is going to resolve them. After speaking with my witness this morning regarding the facts in that case, I no longer believe I can maintain the felony portion beyond probable cause. I believe I must, as the prosecutor, dismiss the weapons complaint on that. Given that, what we'd like is it to be set then with the remaining misdemeanor count 2 for a pretrial, and I think that negates the point for any of the forensic that's pending to be withdrawn. Although that may be addressed.
All right, so let's address that then. That's 22-02496. That's and same appearances we've had for the record. It's my indication today that it is the people's intent. This is the file that there's an outstanding forensic evaluation on, correct?
Correct, Your Honor.
So outstanding forensic evaluation based on conversations with the complaining witness. Plaintiff seeks to move to dismiss without prejudice. Is that my count 1?
Correct, Your Honor.
And reset count 2 as a misdemeanor.
Correct, Your Honor.
And that would be a misdemeanor pretrial.
Yes.
Is that your understanding as to docket 22-02496, Mr. Abbott?
That is my understanding, Your Honor, and I have no objection to modifying the complaint.
All right. So with that understanding that the people will move to dismiss count 1, we'll reset count 2 as a misdemeanor pretrial. You have a pretrial date? I don't think there's any reason. So are you withdrawing the forensic motion, Mr. Abbott? I'm assuming that's dismissed, that you'd be withdrawing the forensic motion.
Yes, Your Honor.
All right. So the forensic motion is withdrawn. Count 1 is dismissed as to the felony. Let me get you a pretrial date for that file.
January 3rd at 9:30.
January 3rd, 2023 at 9:30. That would be a Friday.
Should be a Monday.
It's a Tuesday.
Oh, I'm sorry, I'm not, yeah,
Tuesday.
that's a Tuesday.
Yes, that's
Okay.
under statute day.
Yep,
I'm available there.
all right,
And if it's not me, it will be one of the misdemeanor attorneys.
all right.
Thank you.
So January 3rd, 2023, that's a statute date for us, so at 9:30, so that would take care of docket 22-02496. Do you have a nollie for the?
Yes, Your Honor.
All right, thank you. And that's as to count 1 only, correct?
Correct, Your Honor.
All right, and Mr. Abbott, you probably have to file some like a motion to withdraw that forensic,
I will.
just so they have it in paper, you know.
Right.
All right, so anything else for the record, docket 22-02496, Mr. Wisty?
No, Your Honor.
Anything, Mr. Abbott?
No, thank you.
All right, so,
Well, bond,
but if it's dismissed, it's down to the misdemeanor bond, right?
right. Currently, its bond is $5,000 cash or surety. I'd ask the court to move that to a misdemeanor bond.
All right. Any comment on bond? That leaves the remaining assault and or assault battery and the second file that we're gonna have testimony on in regards to count. So count 2 is left. Any question on bond? Any comment on bond, Mr. Wisty?
Yes, Your Honor, I do believe bond is still appropriate even without a weapons complaint. There's no denying without a weapons complaint. I think lowering of some degree is, I think that's undeniably appropriate. This are a series of violent offenses that have been going on for a series of time involving the same victim. So I would request some bond, and I would have to concede that a reduction is reasonable given that.
Right. Yeah, this 5,000 cash or surety is for the felony count. This is an assaultive crime, and there's still the assaultive crime avenue concerning the other file. So I will set bond on this matter. So bond is revisited and set at $3,000, 10%. So that's a new misdemeanor bond on that file. And then we can go as to docket 22-02320. Parties have already placed their appearances for the record. I do have a forensic evaluation in that case. Mr. Wisty, how are we proceeding today?
We're proceeding with the examination, Your Honor.
And we've already skipped to the evaluation on November 28th. Mr. Abbott, is that your understanding?
Right, we stick to its admissibility. There was an argument about whether it should be agreed with or not, but you did sign an order finding him competent.
Correct. All right, any discussion concerning any preliminary matters before we start the preliminary examination?
Just for the record, there has been a signed stipulation for the witness Cindy Cheney to testify via Zoom televideo software.
I did sign that. I saw that earlier in the week. Mr. Abbott, is that correct?
That's correct, Your Honor.
All right. Anything else preliminarily before we get started?
Nothing for the people, Your Honor.
Anything, Mr. Abbott?
Not from the defense, thank you.
All right, and is she connected to audio yet? Okay, she is. All right. So pursuant to the stipulation, Mr. Wisty, you may call your first witness.
I call Sydney Cheney, Your Honor.
All right. And ma'am, you are Sydney Cheney?
Yes,
And you can hear me all right, Miss Cheney?
yes, I can.
All right. I'm gonna have you state your name and spell your last name for the record.
Cindy Cheney, CINDY CHANEY.
Okay, I'm gonna have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, I do.
All right, Mr. Wisty, you may proceed.
Thank you, Your Honor. Good morning, Ms. Cheney. Do you know
Good
an
morning.
individual by the name of David Lee Cheney?
Yes,
And who is he to you?
it's my son.
And do you see him here today? Are you able to see the Zoom courtroom this morning?
Yes,
And do you see Mr. Cheney here?
yes, I do.
Could you identify something he's wearing or where he's seated on your screen?
Really, all I can see is his head.
Let's see if we can move the camera.
He's got a gray jumpsuit on
I let the
and a
record
white
reflect.
shirt.
So did you want to let the record reflect the witness identify the defendant?
Yes, Your Honor.
Mr. Abbott, any objection?
No objection.
Okay, without objection, the witness has identified the defendant.
And Ms. Cheney, did something occur between you and your son on July 26, 2022?
Yes,
What was the nature of that occurrence? Was there an
I don't
argument
know.
between?
he was trying to stop me from leaving. He was trying to stop me from doing anything unless it was what he wanted done.
I'm gonna back you up a little bit, okay?
Okay,
So where did this take place?
in the house. At
What's the
home,
address of the house?
3508 Coach Light Commons.
And is that city of Lansing,
Yes,
county of Ingham?
yes,
And at the time you resided in the house with Mr. Cheney,
yes.
some sort of confrontation came to be between you two. How did it begin?
He was getting agitated. He wouldn't let me leave. He grabbed the phones, the cell phone.
When he grabbed the phone, that when he was agitated and wouldn't let you leave, what did you try to do as a result of that?
Well, I tried to sneak in my bedroom to get my phone that was in there, and that was already gone.
What did you
So
intend to? I apologize, I'm just cutting you off so we get a clear record. What did you intend to do with the phone?
I was gonna call the police on him.
So after you went to get your phone from upstairs, what did you do next? You were
He got
upstairs and
more,
you didn't,
he got more agitated, and then I had to finally sneak out in the pouring rain and walk down the road to my kids' house to get help.
and at some time, did you get a phone sometime that evening to try to call 911?
Yeah, when I walked down to my other kids' house, yes, I did finally call the police.
And when you were trying to call the police, did Mr. Cheney do anything?
I didn't hear that.
When you were trying to call the police, did Mr. Cheney do anything?
One phone he broke. The other one I still haven't found. But like I said, he would stop me from leaving the house. He'd use force. He grabbed my arm. Finally, I got away. That's all I can say. I finally got away and I went and called for help. But a lot of
When
it
he was-
had to do, a lot of it had to
Go
do
ahead.
with what he was, the pills he was taking too.
Do you feel you would have been able to call 911 if but for his actions?
Yeah, I could have sooner, yes.
And what did he do specifically to stop you from doing that?
Like I said, he grabbed my cell phone, he grabbed the home phone. He broke one of them, so. And I don't know what he did with the other one.
No further questions, Your Honor.
Cross-examination, Mr. Abbott.
No, thank you.
May this be excused, Mr. Wisty?
Yes, Your Honor, and if I may approach briefly.
Sure. Mr. Abbott?
This is the one where she'd like to speak.
Okay, yeah, we'll keep on the Zoom afterwards. And then what, set them up for on Polycom or not it? I don't think you can put them on iPad. You can. All right, and so we'll put them in a breakout room afterwards. Any further proofs, Mr. Wisty?
No, Your Honor.
Any proofs from the defense, Mr. Abbott?
Nope.
All right. May this witness be excused, Mr. Wisty, and I'll ask the witness to stay on, to stay on the call until they're directed to any type of directed to leave or additional rooms. So may this witness be excused from testifying?
Yes, Your Honor.
Any objection, Mr. Abbott?
No.
Ms. Cheney, I'm gonna have you stay on the Zoom courtroom call, and then we'll direct you from there, okay, ma'am?
Okay, thank you.
All right, so just stand by. Argument, motion for bind over, Mr. Wisty.
Your Honor, I would move to bind over as to count one, interfering with an electronic communications. We heard testimony here today from the witness, Ms. Cheney, that there was a argument that turned physical between her and her son, the defendant, whom she identified at the home that was testified to be in Ingham County. During that dispute, she attempted to get her phone to call. Ultimately, the defendant took one of those phones and your testimony, in fact, broke it, thus preventing her from calling 911. That meets the elements of count one, Your Honor, and I believe there's enough to bind over this morning.
Thank you. Response, Mr. Abbott.
Your Honor, there was no testimony that she was actually making a call. There was no testimony that she had actually dialed a number or had established a communication. She testified that he threw the phones or he hid the phones, and that she went to the neighbors and made a call, but she never testified that she was in the process of making a call and that he actually interfered with that call. So I don't think that the elements have been met, Your Honor.
Response?
Your Honor, I believe that was meant to, she interfered with the call she was attempting to make, and I would point out the statute includes delay by any means as an element that can result in this. One of the elements can study the statute can be delayed by any means. I think certainly we heard testimony that meets at least that portion of the charge.
All right, thank you. So the standard of the standard at preliminary examination is probable cause. Probable cause being the second lowest standard for purposes of bind over, reasonable suspicion being the lower standard, beyond a reasonable doubt being the conviction standard in circuit court. The court finds that identification's been made of the defendant. The date of July 26, 2022 has been made. The venue in the city of Lansing, at the 3508 Coach Light Commons address, city of Lansing, Ingham County. And so what the court is left with is the offense of interfering with the electronic communications, that felony. There seems to be testimony that the defendant is the son of the witness, Cindy June Cheney, and that they both reside together at that Coach Light Common address. They got into an argument that turned into a fray of some sort. The witness testified that while she was attempting to call for help, at least more than one time it appears, but he broke one phone, that being the cell phone, and he lost another phone at that time. And then she was able to exit the location and go get help. There seemed to be testimony that she tried to send some type of conveyance. So the elements of the crime are: first, the defendant prevented, obstructed, or delayed by any means the sending of authorized communication through communication or a cell phone device. That's been met. Second, the defendant did willfully and maliciously. This means the defendant did act on purpose with the intent to prevent, obstruct, or delay the communication. At least from this witness's testimony, she indicated that she was not able to make the phone calls necessary to seek help, and that this defendant was the reason for that. I find that the elements of interference with electronic communications have been met in order to bind this case over to circuit court on the felony 2-year and/or $1,000. Anything else in regards to, so this case is now done in district court and moves to circuit court where there's a trial. If there's going to be a trial, that's where it will be held in circuit court. So the case is bound over on count 1. Count 2 follows as a misdemeanor. Mr. Wisty, anything further in this case on this file in regards to this file?
No, Your Honor.
All right. Mr. Abbott, any comment or anything else on this file?
Nothing further on this file, Your Honor. Regarding bond, it's currently set at 2,010%, Your Honor.
Yeah. Yeah.
And he's been in jail for 5 months. I'd ask the court to consider a personal recognizance on this case.
I understand that. I understand the motion. I'm unwilling to reduce the bond at this point in time based on the testimony that I heard. There's still the evaluation out and there's still another prior misdemeanor, another misdemeanor case. I think that can be revisited in circuit court, of course. But for my purposes, based on the testimony, I'm going to leave bond the same. So that's all for the record in docket 22-02320. Miss Cheney, if you stay on your Zoom call, we will set it up so you have some time to discuss this matter with your son and the lawyer, okay?
Okay, thank you.
All right. So Mr. Abbott, however you want to do that, but we'll set him up on the iPad, okay?
Okay, thank you.
All right. That's all for the record in docket 22-02320, and then we'll have the defendant taken down to receiving.
Thank you, Your Honor.
Get out.